Welcome back to the Constitutional Clarion. In my previous videos, I've explained about the precedents for blocking supply at the state level in Australia. In this video, I'm going to address the power of the Senate to block supply and the extent of any convention restricting that power. In doing so, I'm going to show how both sides were inconsistent and in fact utterly hypocritical on this point prior to the 1975 dismissal. In much of the commentary on the 1975 dismissal, you'll see assertions that the Senate didn't have the power to block supply or that it breached a well-established convention in doing so and therefore behaved reprehensibly. So let's start with the power. On the one hand, as long as the approval of both houses is needed to pass a bill, including a supply bill, then of course the upper house has legal power to refuse to pass supply. This, however, depends upon the law in the particular jurisdiction. In the United Kingdom, the Parliament Act 1911 removed the power of the House of Lords to reject money bills. In some Australian states, such as New South Wales, the upper house has no power to reject money bills. In Victoria, that change was made more recently in 2003, after that very long history of supply disputes that I outlined in the previous video. In the absence of some legal constraint upon the power of an upper house to block supply, the argument has been made that unelected upper houses lack democratic legitimacy and are therefore not entitled by convention to reject money bills. This is because the power of the purse is vested in the popularly elected lower house. This argument is more difficult to run where there is an elected upper house. In Australia, the Senate is directly chosen by the people by way of proportional representation. From a party perspective, it's therefore probably more representative of the political wishes of the people than the House of Representatives. But of course, from a population perspective, the wishes of the people are distorted because each state has equal representation in the Senate despite vastly different state populations. The framers of the Constitution struggled through the convention debates to reach agreement on the power of the Senate in relation to money bills. The framers were themselves current or former politicians, many of whom had lived through bitter fights between the houses over money bills. In the end, their compromise, as set out in section 53 of the Commonwealth Constitution, was that money bills had to originate in the lower house and could not be amended by the Senate. But the Senate could return a money bill to the lower house requesting amendments. Otherwise, the Senate, quote, shall have equal powers with the House of Representatives in respect of all proposed laws, unquote. That means that the Senate can reject or fail to pass a supply bill. It undoubtedly has the legal power to do so. That then brings us to whether there's a convention that should prevent the Senate from rejecting or deferring the passage of a supply bill. The mere fact that something has not happened before doesn't necessarily mean that there's a convention that it should not be allowed to happen. It may simply be the case that the circumstances have not been such as to cause it to happen. More is needed to establish a convention. The classic test for a convention laid down by Sir Ivor Jennings is that you need 1. Precedents, 2. A belief amongst the actors involved in the precedents that they were bound by a rule, and 3. A reason for that rule. I would add that the reason for the rule must be to give effect to a fundamental constitutional principle, such as responsible government, the separation of powers, or the rule of law. When it comes to the question of whether the Senate is bound by convention not to block supply, are there any precedents? Well, the Fadden government resigned in 1941 after budget estimates were reduced by the sum of £1, but that occurred in the lower house. Supply has never been affirmatively blocked in the Senate, although the Senate has pressed its requests for amendments to money bills, including supply bills, effectively blocking them until the House of Representatives agreed to the requested amendments, or withdrew the bill and replaced it with something more palatable. At best, one could say that there was an absence of precedents for expressly blocking supply, while there were some precedents for effectively, temporarily blocking supply through pressing requests for amendments until the Senate was satisfied that the changes had been made. What about whether the political participants felt bound by the rule not to block supply in the Senate? Now, this is where any convention falls into a heap, at least prior to 1975. This is because the words and actions of the political participants show that they took different views on what the rules were, depending on whether or not they were in government or opposition. For example, here is the view expressed by Labor Senator Lionel Murphy as Leader of the Opposition in the Senate on the 12th of May 1967. He said this, quote, "There is no tradition, as has been suggested, that the Senate will not use its constitutional powers whenever it considers it necessary or desirable to do so in the public interest. There are no limitations on the Senate in the use of its constitutional powers except the limits self-imposed by discretion and reason. There is no tradition in the Australian Labor Party that we will not oppose in the Senate any tax or money bill or what might be described as a financial measure. We in the Senate are democratically elected by the people of the states. If we consider it to be in the public interest that a measure be rejected, who gave us the right to refrain from doing so under some pretended notion that the Senate cannot reject a tax or a money bill?" Unquote. On the 18th of June 1970, Senator Murphy stated that in opposing money bills, the opposition was pursuing a well-established tradition and that there were no limits on the Senate's use of its constitutional power to reject financial measures other than discretion and reason. To illustrate that tradition, he listed 169 occasions upon which Labor had opposed money bills in the Senate since 1950. Later that year, the Labor opposition opposed the Gorton coalition government's budget. Senator Murphy stated on the 26th of August 1970 that his party would oppose the budget and, quote, "do whatever it can to drive this government from office," unquote. It's very clear that Murphy supported the view that the Senate could legitimately use its powers to defeat supply bills in order to force a government in the lower house to an election. In the House of Representatives, the then Leader of the Opposition, Gough Whitlam, said on the 25th of August 1970, quote, "Let me make it clear at the outset that our opposition to this budget is no mere formality. We intend to press our opposition by all available means on all related measures in both houses. If the motion is defeated, we will vote against the appropriation bills here and in the Senate. Our purpose is to destroy the budget and to destroy the government which has sponsored it," unquote. His view was again pretty clear about using the Senate to force out an elected government in the House of Representatives. At the time, it seemed to appear perfectly okay to him. While the opposition tried to persuade the members of the Democratic Labor Party, who held the balance of power in the Senate, to join Labor in blocking supply, it failed and supply was passed. Now, this wasn't because Labor was trying to uphold a convention that it accepted. It was because it just didn't get the numbers. Nor can one say that the DLP was committed to preserving an accepted convention because its senators were happy to support the deferral of supply in 1974 to try and force the Whitlam government to an election. But back to 1970. The opposition did manage to defeat a tax bill which was introduced by the Commonwealth on behalf of the states after state laws imposing the same tax had been struck down by the High Court. It was rather ironic that a power given to the Senate for the purpose of protecting the interests of the states was actually used by the Senate to reject legislation intended to protect the interests of the states. In 1974, when the Labor-Whitlam government was in office now, it was the coalition which opposed supply bills in the Senate. It moved to defer consideration of the supply bills until the government in the lower house submitted itself to the people in a general election. The leader of the government in the Senate, Senator Murphy, moved the closure to the debate and said that if the government was defeated on the closure motion, it would treat this as a denial of supply and act accordingly. The government lost the vote and proceeded to request and be granted a double dissolution election, which meant that the full Senate was forced to face election. In 1975, when the coalition opposition in the Senate again sought to pressure the Whitlam government to an election by deferring the passage of supply, Whitlam announced that this time he would not seek a general election or resign. In contrast to Senator Murphy's arguments expressed in 1967 and 1970, Whitlam told the House of Representatives on the 28th of October 1975, quote, "It is specified in our Constitution, it is explicit in our Constitution, that the House of Representatives initiates money bills. The House of Representatives alone can amend money bills. The Senate can neither initiate nor amend money bills. It can make requests which the House of Representatives may or may not heed. Money is the sinews of government. The taxpayers' control over their money through their elected representatives in the People's House is the foundation of parliamentary democracy. Under our Westminster system, this control is firmly lodged in this House. Governments are made and unmade in the House of Representatives, in the People's House. The Senate cannot, does not, and must never determine who the government shall be. The opposition in the Senate asserts that there has never been a convention that the Senate, the upper house, should not reject the money bills for the annual services of government. This is an assertion without foundation. In the 75 years of our federal history, no opposition has ever withheld passage to these bills, despite the fact that on some 20 occasions, the government of the day did not itself have a majority in that other place. A convention has been established that the Senate, which cannot originate or amend bills for the ordinary annual services of the government, does not block them either. This is but yet another abrogation of a well-established convention. It is part of a deliberate pattern on the part of the opposition of challenging the role of conventions in the operation of the Constitution in its lust for power." Unquote. The leader of the opposition, Malcolm Fraser, took the opposite view in the House of Representatives on the 30th of October 1975. He argued that the Constitution specifically gives to the Senate the powers and the concomitant responsibility to bring a government to the judgment of the people if, in the opinion of the Senate, that government will do serious and irrevocable harm to the people of Australia by remaining in office. Fraser pointed to Section 53 of the Constitution, which does not remove the Senate's power to reject or defer the passage of money bills, and noted that the High Court justices had accepted that the Senate has the power to reject appropriation bills. He argued that the power must be used discreetly and with the greatest of caution, and that the fact that it has not successfully been used in the past was no argument for not using it in the current circumstances. He saw the power as a tool to force a government to account to the people at the ballot box. He said, "If the people agree, the Senate unmakes the government." Unquote. As you can see, at least in 1975, the second element of a convention was missing. The participants on both sides did not feel themselves bound by any rule about the Senate not blocking supply. Both sides had said contradictory things about it. The third element of the definition of convention is also important here. Was there a reason for the rule that gives effect to the fundamental constitutional principle? The problem is that there are constitutional principles which support each side of this argument. On one side, it can be argued that the principle of responsible government means that a government is formed from and responsible to the lower house, and it does not need majority support in the Senate. Yet on the other side, it can be argued that the principle of federalism resulted in an elected Senate with full power to reject money bills and a direct democratic mandate. Further, it's long been recognised that a government cannot govern without supply. So if it cannot achieve the passage of supply, it must resign, secure an election, or face dismissal. Most governments choose an election in those circumstances, and that's also what the Verron government did in South Australia in 1912 and the Cosgrove government did in Tasmania in 1948 when upper houses blocked supply to them as well, in addition to all those Victorian precedents I gave you last time. Whitlam himself chose the election route in 1974, but in 1975 he chose to crash through or crash, and he crashed. Thank you for watching the Constitutional Clarion, and join me next time for a video on the 1974 double dissolution and the Gare affair. See you then. Goodbye.